I rise today in opposition to the nomination of Solicitor General Elena Kagan to be an Associate Justice of the United States Supreme Court. Upon President Obama's nomination of Ms. Kagan, I stated that I would base my decision ultimately on what I could ascertain about her judicial philosophy from other components of her record in light of her lack of judicial experience. What little information she offered during her confirmation hearings did not accrue to her credit in my judgment. Mr. President, I'm unconvinced that the hostility Ms. Kagan demonstrated toward the Second Amendment as a clerk to Associate Justice Marshall and as counsel for the Clinton administration and as Solicitor General under President Obama has changed or would not drive her legal opinions on that matter. Ms. Kagan has spent her career implementing anti-gun initiatives, and evidence of her antagonistic attitude towards the Second Amendment can be found from the beginning of her legal career as we examine the record. Mr. President, way back as a Supreme Court law clerk in 1987, Ms. Kagan stated, and I'll quote, that she was not sympathetic toward a man who contended that his constitutional rights were violated when he was convicted for carrying an unlicensed gun. Think about it. In a memorandum to Justice Marshall regarding Sandage versus the United States, Ms. Kagan wrote that Mr. Sandage's, quote, sole contention is that the District of Columbia's firearms statutes violate his constitutional rights to keep and bear arms. I'm not sympathetic, she said. She recommended that the Supreme Court not even hear the case, thereby allowing Mr. Sandage's conviction to stand. And when Ms. Kagan served as a political advisor to President Clinton, she played a key role in the gun control efforts that were a trademark of the Clinton administration. Ms. Kagan took a lead role in a series of efforts to respond to the Supreme Court's 1997 ruling in Prince versus the United States, which struck down parts of the 1993 Brady handgun law. Mr. President, Ms. Kagan drafted proposals that would have effectively prohibited the sale of guns without action by, quote, a chief law enforcement officer. She authored a draft executive order requiring, quote, all federal law enforcement officers to install locks on their weapons, and one to restrict the importation of certain semi-automatic rifles. Ms. Kagan drafted two memorandums, Mr. President, in 1998 that advocated for policy announcements on various gun control proposals, including, I quote, legislation requiring background checks for all secondary market gun purchases and a gun tracing initiative. As Solicitor General of the United States for President Obama, Ms. Kagan failed to find, Mr. President, a federal interest in the McDonald versus Chicago case and did not even file a brief in the case as Solicitor General. Assaults on the Second Amendment will not end with the McDonald versus Chicago ruling. Therefore, the overarching question remains, I believe, will Ms. Kagan's attitude as Supreme Court Justice radically change from her clear and extensive anti-Second Amendment record? I firmly believe, Mr. President, that the right to bear arms is a fundamental right. This has been enunciated through the courts. I do not believe Ms. Kagan's political record and prejudiced background in opposition to the Second Amendment shows that she's prepared to uphold the core constitutional guarantee as a Supreme Court Justice. In fact, Mr. President, Ms. Kagan's record has demonstrated a disregard for those laws and constitutional rights that she disagrees with. This is also clearly evidenced in her affront to our men and women in the military, and I will explain. As a vocal critic of the military's don't ask, don't tell policy, Ms. Kagan barred military recruiters from the Harvard campus during her time as Dean of the Harvard Law School. Mr. President, she made her personal feelings unmistakably clear by repeatedly stating that she abhorred the military's don't ask, don't tell policy, calling it a moral injustice of the first order. Mr. President, by barring recruiters, Ms. Kagan's actions violated the Solomon Amendment, which is the law, which requires that the military receive equal access to that of other employers on campus or jeopardize their federal funding. Ms. Kagan joined a brief, think about it, Mr. President, joined a brief before the Supreme Court arguing that Harvard should be able to keep military recruiters off campus but still receive federal funds, although that was in violation of the law. She refused to permit ordinary campus access to military recruiters during a time of war, yet still wanted, Mr. President, to cash in on federal funding. This position was unanimously rejected in 2006, with the Supreme Court stating that this was clearly not what Congress intended. Mr. President, I find it ironic that we're asked to replace the only justice with wartime experience with a nominee who willingly obstructed our military during a time of war. It's unacceptable, I believe, to limit the ability of our armed forces to recruit on campus at a time when the United States is fighting two wars. Mr. President, I have serious concerns about her actions against the military and her willingness to prevent access to potential recruits during a time of war. This incident, I believe, illustrated her liberal agenda superseding her professional judgment. Mr. President, I've highlighted only two issues of many that exemplify Ms. Kagan's well-defined political record. Put simply, Mr. President, she's a political activist, I believe, and not a jurist. Throughout her confirmation hearing, she failed utterly to explain where her political philosophy ends and her judicial philosophy begins. Mr. President, I believe we need a legal mind on the Supreme Court, but not a political one. We need an impartial arbiter, not a partisan political operative. Therefore, Mr. President, I would firmly oppose Ms. Kagan's nomination to be an Associate Justice of the Supreme Court.